You know what nobody talks about at bridal showers? Not the cute little finger sandwiches, not the who knows the bride best quiz. Nobody is standing up and saying, hey, before you walk down that aisle, let's talk about what happens to your house, your business, and your retirement account if this whole thing goes sideways. Nobody wants to be that person at the party. But lucky for you, I'm absolutely that person. I'm Shari Rivkind. I'm an attorney with over 38 years of experience, and I'm co-founder of Bridelawyer. I have spent nearly 4 decades watching couples walk into marriages completely blindsided by what the law says about their money, their homes, their businesses, and I have spent just as long helping people on the other end of that mess, trying to put Humpty Dumpty back together again. That's expensive, that's painful, and so much of it is completely preventable. So today I am going to give you the 8 biggest reasons why you, yes you, need a prenuptial agreement. And I'm not talking about just the mega rich. I am not talking about people with private jets and vacation homes in the south of France. I'm talking about regular people. People who own a house, people who have retirement accounts, people who have kids from a previous relationship, or plan to start a business someday. This is for you. We're going to count down from 8 to 1. And by the time I get to number 1, the biggest reason of all, I want you to pick up the phone and call Bridelawyer, or call a family law attorney if you don't live in New York and New Jersey. Deal? Let's go. Reason number 8. One of you owns a home. All right, number 8. And I want you to hear me on this because this is the one that people completely underestimate. If one of you owns a home, the home that you two are planning to live in together, you need a prenup. Period. Full stop. Done. Now I know what you're thinking. You're thinking, Shari, it's my house. I bought it before we got married. The law says it's mine. And you're right. Generally speaking, assets you own before the marriage are considered separate property. The law says so. But here's where it gets dicey. Here's where I've earned my gray hairs. The marital home is typically one of the biggest assets a couple has. It's where wealth is built. So if you come into the marriage already owning that home, your partner is essentially giving up the opportunity to build that wealth through their own property. They are contributing to a household, paying bills, doing renovations, maybe raising kids there. And from a legal standpoint, their fingerprints are all over that asset. Here's the concept I need you to understand. Post-marital income. Every dollar earned after you say I do is generally considered marital income. So if your spouse's paycheck goes towards the mortgage, even partially, they're now contributing marital funds to something that was your separate property. And when you do that, we have a word for that in family law: co-mingling. Co-mingling is when you take something that's entirely yours, something the law that says belongs to you and you alone, and you mix it up with marital money or marital effort. And once you do that, the lines get very, very blurry. What was crystal clear, that's my house, becomes, well, a portion of that house is arguably marital property. Now let's say the worst happens and the marriage ends. You might be sitting across from a judge who is looking at years of mortgage payments, years of shared expenses, maybe a renovation that was paid out of a joint account. And that judge may say that your spouse is entitled to a claim on that home. Not necessarily the whole thing, but a claim. And here's the problem. You can't divide a house in half like a piece of pie. So what does that mean practically? Well, it means that either you're going to have to sell that house that you love, and split the proceeds, or one of you has to buy out the other. Either way, someone's scrambling for cash in a situation which is already one of the most emotionally devastating to begin with. A prenup lets you sit down before any of this happens and say, we agree that this house belongs to me. If you move in, here's how we're going to handle the ongoing expenses. Here's what's fair. Here's what we're both decided. Not a judge who doesn't know us, not a courtroom battle. Us. That's the whole point. You're writing the rules. You're not leaving things to chance or leaving them for down the road. Reason number 7. One of you owns a business. Okay, number 7. And this one's a biggie. One of you owns a business or plans to someday. And if you think that has nothing to do with your marriage, I need you to pull up a chair and sit down with me for a minute. Let me start with the basic rule, because this is going to be our foundation for the next few reasons. Ready? All income earned after you get married is shared. Period. That is the general rule in most states. Marital income belongs to both of you. Whether you earned it or your spouse earned it, it's joint, no matter whose name things are in. Now, a business has a value all its own. There's entire companies that exist solely to value them. They call it a business valuation, and it's often a multiple of what the company makes each year, plus assets, goodwill, customer relationship, trademarks, all of it. Those numbers can get big very quickly. So here's the question. Was the business started before the marriage or after? If the business existed before the wedding, then the business itself is technically separate property, as long as you keep it separate. That's the operative phrase. Keep it separate. But the income that business generates after the wedding, that's most likely marital income. You can see the problem already. Now here's where it gets sneaky, and I have seen this play out more times than I can count. You're married. The business is ticking along, and then the marriage starts to hit rough waters. Suddenly, coincidentally, your spouse starts sinking money back into that business. New equipment, more employees, expanded facilities. They are taking money that would otherwise be marital income, and they're funneling it back into their separate asset. Now, to be clear, businesses reinvest themselves all the time. This is normal and healthy. But in the context of a failing marriage, it can be strategy, conscious or not. Can you fight it in a divorce? You absolutely can. But you're going to be hiring forensic accountants, business evaluators, attorneys who specialize in this stuff. You're going to be sitting through years of documents. And that divorce bill, forget about what you imagined. We're talking about a potentially enormous legal cost. And you'll be spending months, sometimes years, in court. And what if the business started after the wedding? Well then, my friend, that entire business belongs to the marriage. Even if your spouse built it from the ground up, even if you had nothing to do with it, even if they made every decision, half of it legally is yours, or legally theirs, depending on which side of the table you're on. A prenup can expressly provide that any business an individual owns, operates, or is actively involved in stays in their column. It does not have to be a punishing provision. It can be completely fair to both parties. But if you need it written down before, you need it written down before any of you have any idea how big that business might become. Think about it. Jeff Bezos founded Amazon the year he got married. You see where I'm going with this? Reason number 6. One of you is a licensed professional. Number 6, and this one has a particular place in my heart because, well, I'm a lawyer. So when I say professional, I mean a licensed professional. Doctors, lawyers, pharmacists, dentists, physical therapists, accountants. These are people who own licenses, and those licenses are considered valuable assets. They represent earning potential. They represent years of education and training, and they're protected in very specific ways that differ from state to state. You know the classic story. One partner works nonstop, maybe 2 jobs, to support the household, while the other one goes to medical school or law school. For 8, 10, 12 years, one person is sacrificing their own career trajectory to fund and support the other's education and training. You would think that sacrifice would be repaid if the marriage ends. You would think. But depending on the timing, depending on what state you're in, depending on whether the parties want to litigate it, it's not always the case. Now here's another weird layer. Most licensed professionals eventually go into practice for themselves. So now we're back to that business conversation we just had, but with an added twist. In most states, a non-doctor can't hold a financial ownership interest in a medical practice. A non-lawyer generally cannot be a partner in a law firm. These are professional rules, not just legal ones. So here's the scenario. Let's say the practice started after the wedding. Under general marital property rules, that means the practice is joint. It belongs to both of you. But the law also says that your non-medical spouse can't own an interest in a medical practice. So what does the court do with that? The answer is the non-doctor spouse gets the value of their interest, even if they can't actually own a piece of the practice. And many medical and dental practices, they're worth millions and millions of dollars, which means half that value belongs to the other spouse. And since you cannot just write a check for $2 million on the day the divorce is finalized, the doctor's spouse inevitably ends up giving everything else up to compensate. The house, the investments, the savings accounts, everything goes to the other party to balance out that practice. I have known physicians, brilliant, successful physicians, who kept their practices after divorce and moved into small, dumpy apartments because there simply wasn't enough cash left to give them anything else. A prenup doesn't have to be cold or greedy. It can acknowledge that sacrifice. It can provide for fair compensation. But it lets both of you walk into the marriage knowing exactly what the deal is, rather than finding it out in a courtroom 15, 20 years later. Reason number 5, you have kids from a prior relationship. Number 5, and this one hits close to home for a lot of people. If you have children from a prior relationship, a prenuptial agreement is not just smart, it's one of the most loving things you can do for those kids. Think about it this way. You've built something. Maybe it's a home. Maybe it's savings. Maybe it's investments or a retirement account. You want your children to benefit from what you've built. But if you die, or if the marriage ends, the default rules of your state might not route things the way you intend. In a marriage, assets can pass between spouses automatically, depending on how they are titled, how you are named as beneficiaries, and what your state law says. Without a prenup, it's entirely possible that what you intended to leave your children ends up going to a new spouse or a new family, or getting tied up in probate in ways you never anticipated. A prenup can expressly provide that certain assets, your home, your savings, your business interests, are earmarked for your children. It can also provide for ongoing financial support depending on the circumstances and what your state allows. And yes, before anyone asks, custody and child support cannot be determined in a prenup. The court retains jurisdiction over children's welfare. But other provisions? Absolutely. Those are things you can address. And for those of you who are marrying someone with kids, this conversation matters to you too. Understanding what your partner intends for their children and what's off the table is not pessimistic. It's an honest conversation. And having it before the wedding is so much better than having it in a lawyer's office 7-10 years in. Reason number 4, you have savings or investments in your name. Number 4, and I will tell you, this is one of the most common reasons people come to me for a prenup. And it's also one of the most misunderstood. You have money. Maybe you've been working and saving since you were 22. Maybe you just sold something. Maybe you inherited a sum. Whatever it is, you have savings and investments in your name, and they belong to you before the marriage. Here's the trap. The law generally agrees separate assets stay separate, as long as you keep them separate. But people commingle all the time without realizing it. You take your savings and you use them as a down payment on a vacation home, and you put it in both of your names. Suddenly, what was yours is now shared. You just gave away half of it without meaning to. Here's one example I love to use because it makes people's eyes go wide. You take 80 grand of your savings, money you had before the wedding, and you use it as a down payment on a vacation home that you put in both of your names. That money, it's considered a gift to the marriage. Half of it is now your spouse's. And if the relationship ends and that property has gone up in value, you're getting a share of something you funded. But you're not getting credit for that full $80,000 you brought to the table. A prenup can protect those assets. It can spell out, this money is mine, this investment account is mine, and if I choose to use it towards a joint asset, how we're going to credit that contribution. It creates a paper trail that a court can actually follow, instead of everyone arguing about whose money paid for what 10 years after the fact when nobody remembers. Reason number 3, one of you has a great retirement benefit. We're down to number 3, and this one is near and dear to most people because this is the safety net, your 401k, your pension, your IRA. These are the things you picture when you imagine life at 70, comfortable, secure, not worrying about how you're going to pay the bills. And I completely understand why people are fiercely protective of them. Here's the reality. Whatever you have in those accounts before the wedding is yours. The law recognizes that. But from the moment you say I do, the contributions you make to your retirement accounts, the value that accumulates from that point forward, becomes a marital asset. It belongs to both of you. For pensions specifically, this can be a huge deal. Pensions are calculated on years of service, on salary, on formulas that can result in very significant monthly payments down the road. The portion that a pension earned during the marriage belongs to both parties. If the marriage ends, there's legal mechanisms, things like quattros, for those of you in the know, to divide pension benefits between former spouses. And once that happens, your salary, your safety net, has a hole in it. Now, a common provision in prenups is that each person gets to keep their own retirement accounts totally separate. That's a provision that most courts generally respect and gives both of you peace of mind knowing that your retirement future is your own. But, and this is important, for ERISA-based plans like most 401ks and pensions, not IRAs, the prenup alone may not be sufficient. Once you're married, your spouse has legal rights to those accounts, and they may need to sign a formal waiver. You get them from your HR departments. The prenup sets the intention. The waiver makes it enforceable under federal law. Your attorney will walk you through this, but you can't skip that one step. Reason number 2, you expect or have a large inheritance. Number 2, and I want to tell you, this one comes up constantly, not just from the people getting married, but from their parents. Here is the baseline rule, and this is one that actually works in your favor. An inheritance is considered separate property, even if you receive it during the marriage. Unlike most other things that come in after the wedding, a gift, a bequest, money from a trust, those stay separate. The law recognizes that these are family wealth transfers, not marital income. But there's that word again, commingling. If you take your inheritance, your grandmother's $300,000 that she left you, and you put it into that joint bank account, you've just commingled it. Or if you use it to pay off a joint mortgage or invest in joint property, or it gets mixed in with marital funds in ways that are hard to trace, you've got a real problem. What was clearly separate becomes muddled. And here's the less obvious scenario that almost nobody thinks about. Some people have very large trusts, real money coming in, sometimes every month, every quarter, from a family trust established by their parents or their grandparents. Significant income. And that trust income comes in during the marriage, so it can be treated as marital in certain circumstances. Imagine this, your spouse is the beneficiary of a substantial trust. They don't need to work, they've got the income covered. Meanwhile, you're out there every day grinding it out. At the end of a marriage, a court might actually look at the income disparity and determine that you owe your partner alimony because the trust's income has supplemented or replaced their income capacity, and your income is considerably higher by comparison. Or you might make a claim that their inheritance is monthly income. Messy. I know, it sounds crazy, but it happens. This is why I tell you, when parents come to me worried about what happens to the money they're leaving their child if the marriage goes wrong, a prenup is the answer. It can expressly state that inheritance remains separate under all circumstances. It protects your family's legacy. Reason number 1, you only get one shot. And here we are, number 1, the biggest reason of all. You only get one chance to do this. A prenuptial agreement must be done before the marriage. That's not a technicality. That's the entire premise. Once you're married, the legal landscape changes completely. You're now considered fiduciaries to each other, which means you're legally obligated to act in each other's interest. The power dynamic shifts, the incentives shift. Now, I know you have probably heard of postnuptial agreements, a postnup, done after the marriage. And yes, they exist, and yes, they can be very valid. The courts scrutinize them much more carefully, precisely because of that fiduciary relationship I just talked about. And more practically, the person who does not have the motivation to sign a postnup rarely does. Think about it. Typically, the reason somebody wants a postnup is because something has changed. Their business took off. They came into money. They started a new venture. And the other spouse, who was just fine with the status quo, suddenly has zero incentive to sign away any claim. Why would they? They didn't have to before the wedding. This is why I tell every single young couple who sits across from me, even the ones who look at me like I have 3 heads, you do not need to be rich to have a prenup. You need to have plans. You need to have ambitions. You need to intend to build something. Do you plan to stay broke? No. Then you need a prenup. Because here is what a good prenup does. Yes, it protects the assets you already have. Though honestly, if you keep your separate assets separate, the law generally does that anyway. But what a prenup really does is set parameters for how things are going to work inside your marriage. What happens if one of you starts working to raise kids? What happens if one of you starts a business that takes off? What happens if you use one of the 2 partners' inheritances to buy a vacation home? You write the rules together. When you're in love and when you're thinking clearly and acting in good faith. Think of it like a business partnership agreement. You would never start a business with someone and not put anything in writing, right? Nobody walks into a partnership saying, we're not going to need a contract because we trust each other. You put it in writing because you trust each other, because you both want to understand what the deal is. Marriage is the most important partnership of your life. It deserves at least as much paperwork. Now, what makes a prenup valid? because I don't want you running out and downloading some template off the internet or sitting down on the couch and thinking you can just do it online. Each state has different requirements, but generally speaking, you both need your own attorneys. Not one attorney for both of you, separate attorneys. You both need adequate time to review it. No signing the night before the wedding. Neither party can be forced or pressured. The agreement has to be fair to both parties, and it typically needs to be properly executed, signed, witnessed, and often notarized. Do all that, and in most states, that prenup will hold up. Now, will a court enforce every single clause? Not necessarily. There are things that courts simply will not uphold. You cannot contract your way around custody. You can't include provisions that are unconscionable or illegal. But the core financial protections, done properly, they stick. So there you have it, 8 reasons, and every single one of them is real. Here is my final thought for you, and I want you to sit with this. Getting a prenup does not mean you are planning to get divorced. Getting a prenup means you respect each other enough to have an honest conversation about the life that you guys are going to build together. It means you're adults who understand that love is real and that life is complicated. And you want to protect both of you, not just one of you. If any of these 8 reasons resonated with you, and I'm willing to bet that some of them did, and you live in New York or New Jersey, reach out to Bridelawyer. You know where to find me. Links are below. If you live in another state, find an attorney who really understands prenups. And if this video helped you, share it with someone you love who's getting married. Because sometimes the most loving thing you can do is tell somebody something that nobody else will. I'm Shari Rivkind. Thank you for being here, and congratulations, you're getting married.